Good afternoon. Good afternoon, ladies and gentlemen. The Provost Forum will start in approximately 5 minutes. So at this time, please start finding your seats. Thank you. Once again, good afternoon. The Provost Forum will start in approximately 4 minutes. Thank you. Good afternoon, ladies and gentlemen. Welcome to the Provost Forum on growing our research and graduate programs. At this time, please welcome UCF Provost, Dr. Elizabeth Dooley.
Walking in, but nevertheless, please find a seat. I'm so pleased to see all of you here today. It's a great day, and I believe we're getting near the end of the semester. Is that correct? So in a few weeks, we can say that we're ready for the incoming crowd starting either summer 1 or in the fall. This is the Provost Forum, and I might suggest that this is also under Collective Impact 2020. And one of the things that we've been doing is hosting these Provost Forums to keep individuals enlightened in terms of the progress that we made. This year, we decided to do things a little differently, not only to keep individuals informed of the process, we wanted these to be more interactive. We wanted for those who plan to attend and take time out of their schedule to attend to leave here with something that they can either implement, and I'm sure Dr. Klonoff has that in mind today. So one of the things I'd like to share with you all as we talk about the metrics, in 2018-19, we set a UCF record for research funding with $183 million, an increase of 23% from the year before. I think we should applaud that number. Dr. Liz Klonoff came on board about 3 years ago, and she accepted the opportunity and the challenges to help UCF. She's smiling now. I knew I would get that from her. She accepted the opportunity and challenge to move our research enterprise forward. I also want to applaud all the deans who are in the space today. Please show of hands. And this is not to do an attendance count. I want to applaud all of the deans because without their support, the startup funds and all of the conversations we have, either they're in our office or in conference rooms, we will not result in that number today. I also want to highlight any department chairs who's in the space today. Please raise your hand. When you talk about research, there's a local element, there's a college element, and there's a university element. And from what I can tell and what I can see in terms of the numbers, it takes all of us to move the research metrics forward. So how many faculty members are in the space today? Let's also applaud our faculty members for their contributions. And I want to say, without our faculty members sitting at the core of academics, none of this would be possible. From the teaching, the research, and the service and student success, none of this would be possible without you all. Oftentimes, you may sense that we don't hear or see you. We hear you. I hear you when I'm attending the faculty senate meetings, the steering committee meetings. I hear you when our deans are advocating for you all. I hear you when our vice presidents and vice provosts and associate provosts are advocating for our faculty member. So thank you all for all that you do. Today, we're focusing on enhancing our research excellence, and guiding our discussion today is Dr. Liz Klonoff, Vice President for Research and Dean of the College of Graduate Studies. Dr. Klonoff, thank you for your leadership. I look forward to this forum today.
All right. You can see who's taller. All right, so I got to tell you, this is not going to be as interactive as Provost Dooley would like, in part because we have a lot of information to give you, all right? So the focus, I really can't do this. The focus today is really going to be, there's 4 parts to our focus, all right? The first part is we want to answer the question, how come the people at MIT can do X, Y, or Z and we can't, all right? And so the point of that, good try, Liz, to get out of the people on the stream. All right, anyhow, so the first question we want to answer is, how come the people at MIT or Carnegie Mellon, how come they can do this and we can't? All right? So that question is really going to focus on what's different about Florida, and y'all can interpret that however you'd like. What's different, because I'm from California and I know how I interpret it. What's different about Florida that makes it more difficult, apparently, to do research? So that's the first question. Second question we're going to address is, why can't I just sign a non-disclosure agreement or a material transfer agreement? And in essence, it's the same thing. In one, you're exchanging information, and in the other, you're exchanging a thing. So what is it about these things that are risky, not to the university and to you, that makes it so that we have to look at that? The third thing is, what do you mean I have to say what I'm going to deliver at each time period on a grant or a contract? What is a deliverable? And what can we do about that? And how can we help clarify what our deliverables are so that we increase the likelihood that we actually get paid? Because one of the things that we've done since I've been here is we've moved the grants and contracts accounting into my office, and much to my surprise, I had no idea, there was a bunch of stuff for which we were not getting paid that no one really seemed to care about. But since you all get some F&A returned to you, you should care about it, as should I. And so we're now looking, so the third thing is, what's a deliverable and what should you do about it? And then finally, we're going to talk about some changes that actually have been in effect for about a week. And so it's hard to imagine just how speedy these changes will affect your life. But some changes that have been in effect for about a week that we anticipate will really make a difference in what all of us agree is the biggest bottleneck in the grants and contracts business, and that is contracts. All right? At another time, so part of what we had hoped to do, but we only have an hour and a half, and you're already going to be asleep by the time we're done. But part of what we really wanted to do was demo for you some of the new electronic research administration components too, because we're aware that putting that into place will facilitate all of this. It is our plan, however, to make those available. We've already been reaching out to your department administrators and your college administrators. We'll be reaching out to department chairs and faculty, because we really want to involve everyone in standing this up and in making sure that it is maximally successful. That is, that we all feel as comfortable with it as we possibly can. So here's the deal for today. Everybody's got about 10 minutes of babbling to do. We're going to divide this up into hunks. Everybody's got about 10 minutes of babbling to do, with about 5 minutes available for you to ask questions about their specific area. And hopefully that'll give us some time at the end to have a more general discussion of the new things that we're implementing and what we think they're going to do. But I got to tell you, before I do that, ooh, it's like a whole different, I do want to give you some information, thank you, about, so one of the challenges that I was told we would never meet when I got here was one of the metrics, thank you, Mike Johnson, I appreciate your support. One of the things I was told when I got here was, there's no way we're ever going to get people interested in postdocs. No one understands the value of postdocs. We'll never get to 200 postdocs. And as you can see, as of right now, we actually currently have 178 postdocs, and we have another, another 43 in the pipeline. So if we filled all the postdocs that were in the pipeline, by fall, we will have beat the 200 postdocs criterion that we needed. Well, you understand, it's not me who you should be applauding. It's who you do the next one. It's you guys, because you guys have taken the opportunity to use the postdocs. So postdocs, the P3 program is partially funded by centrally and partially funded by you, and you all have jumped on the opportunity to use that to build your labs and your research areas, etc. And so I want to applaud you for having recognized a great opportunity and capitalizing on it, because I think it's really, really crucial that we continue to build on this and we continue to grow this as well. All right, so I wanted to do that before I did our four-part thing. I do want to spend a little bit of time giving you some numbers, because part of the problem is I'm not sure you are as aware as you might be of just how many things go through our office. By the way, these are underestimates, I'm told, because apparently we switched systems into Cobblestone at some point. And so some of these was moved, some of these were Cobblestone, so the move ones aren't included. These data only represent Cobblestone. So from January 1st to April 9th, which was just last week, we processed almost 4,000 agreements, all right, in 2 years. If you think about that, that is a lot of paper being pushed through, or pixels, depending upon how you view it, all right? And if you look, it says that there's a 47% increase from calendar year 2017 to 2018. But that may be a little bit of an underestimate because 2017 may be missing some of the move ones. But even so, we're a quarter of the way into calendar year 2019. And you see we already have 511. And we have some that are waiting for the Board of Trustees to approve. We've got some that were slow because the government was shut down. So I figure we're going to be well over the 2,000 for 2019. Now, there's really kind of two ways of thinking about our contracts, and that's part of what I want you to understand before we go forward. We have templates and fast tracks. Fast tracks are federal grants for which there's really no legal review. And templates are those things for which people use an existing template that we've already had approved by our legal office, and they go through and they have no legal review. As you can see, we've done 1,443 templates and fast tracks compared to 2,484 contracts that were reviewed by legal. So most of what we do is reviewed by legal. In case you're wondering whether or not we are aware of the time that we track these data, and in our new system, we will be able to track these data even better. So fast track things, about 11 days to execution, which I think is still even a little bit slow, but we got to get it up and running and get the accounts in. For the executed contracts, actually, I know it doesn't feel like it if you're one of the ones who's in the 25%, but actually 75% are under legal review for 5 days or less, and 75% are executed within 2 months, which when you look at what other universities do, 2 months is about the industry standard. Right? Not really terrific, but not really horrible, all right? And it's about 49 total days to execution. And this is just, if you look at all things taken together, 90% are executed in 2 calendar months. So the issue really is not, in general, how quick are we, but it's that from time to time, there are those that feel like they go on forever. So, what I really want to do is introduce the 4 sections that we're going to talk about. So first, Sandra Savinsky is going to help us answer the question, but my friend at MIT can do X, Y, or Z, why can't I? So, Sandra? You want to use this? So you can
I can just use that,
okay.
I think.
Your call, but it won't show up here. Do you know what you're saying? You're a smarter person
paper.
than I am, all right.
Okay, so thank you all for coming. And so as Liz Klonoff mentioned, we do have some unique laws in Florida, and these are things that we have to deal with when we do our legal review, whether or not we're, well, that's going to be talked about later, the new process. So these are the general areas that I'm going to mention: public records law, sovereign immunity, service contracts, random prize drawings, and the contracting party name. These are things that are set out in Florida statute. So first, our Florida Public Records Law. Florida Public Records laws, if you don't already know, are very broad, much more broad, as I understand, than most states. And we're required to not only turn them all over, keep copies we have to keep things for a particular period of time. These are terms that come up quite frequently in industry contracts specifically, and even in things that we get even from other state agencies, believe it or not, and the federal government. Right now, we have exemptions in the statute for research matters and some other exemptions as well. Right as we speak, the legislature, unfortunately, has a bill before them. We'll see what happens to it. But they are looking to remove some of those exemptions with respect to trade secrets and even some of the research exemptions. If they do that, we'll have even more challenges. But these are things that we try to find creative ways to work around. Sovereign immunity. So sovereign immunity, as a state entity, the University of Central Florida is really the equivalent of the state of Florida when we enter into a contract. So we can't be sued without our permission, theoretically. Under the Florida statute 76828, you might run across that once in a while mentioned in a contract. That section of the Florida statute says, okay, never mind the sovereign immunity. We, the legislature, say Florida can be sued for property damage and personal injury, but if we are, it's only going to be limited up to this amount of money, and any other amount of money above that has to go to the legislature, and they have to approve specific funding for any damages above that. So back in the day, we had, I'm going to get ahead of myself. Immunity is limited, and here's why. So a lot of times there's a little bit of a misconception to say, well, we have sovereign immunity, so we can't be sued, so what's the big deal about, all of this worried about us getting sued? This case right here, and if anybody has interest in reading any of these cases, you can totally let us know. We'll send you a copy. This case talks about the right of the state entities to enter into contracts. So when the legislature gave us that right, what also happened is the state says, if you have the right to enter into a contract, then you also have the need to be fully responsible for your breach of that contract. So if somebody sues us for breach of contract, we do not have any sovereign immunity. The caps don't apply. There's no limitation whatsoever. So when we look at the language in a contract, that's why we care, because if UCF gets sued for a breach of contract with no limitation, we're all in trouble. So that's the general about sovereign immunity. Governing law, jurisdiction and venue. So why do we care about that? These are the provisions in the contract where it says, if something goes wrong, we want Florida law to apply. And then that's with respect to governing law. Jurisdiction and venue is, if we do get into a dispute, never mind we say Florida law, where are we going to go to court? Where is that going to have to be? Sometimes people will say, yeah, we'll do Florida law, but we're not going to say where jurisdiction and venue is. Well, we care about both of those things because we want Florida law because we want to make sure that what sovereign immunity we do have, we get to keep. And another state may not agree that that's going to work in our favor. And with respect to jurisdiction and venue, which is where the court, even if the contract says Florida law, if it doesn't say where you're going to go to court, there was a case in Delaware where it wasn't Florida law, but it was a different state's governing law. And the court in Delaware said, we don't care that the people's contract says we agree it's going to be XYZ state law. That doesn't go with our Delaware law, and we're not doing it. So that's why both of those features, if we can, that's our preference. Service contract language, this is another thing, and you might see these edits in a contract and think like, what do they care? Why are they even making a big deal about how big the font is? Why do they care about the font? Because the statute actually specifies. If you have somebody doing services for you, then you have to put this, as a state agency, you have to include this language in this font. I mean, we're not making this up. So this is something that is required. We have a template addendum that gets added in for service contracts. But what this is requiring the service provider to do is basically agree that they're going to be subject to the public records for the stuff that they're doing for us, just like we are. So you can imagine private companies, big and small, are like, no, we don't want that. So we have to have it. We can't help it. Random prize drawings, this is another one. So people want to try to encourage participants in maybe some surveys and things like that. It's maybe common activities in other states in the country. In Florida, if you want to offer people a chance to win something by participating in a project, that's considered a lottery. So it's very specific. I'm not going to go through all of this, but let's just say it's very specific and challenging to implement. And it can't be done through UCF. It has to be done through a nonprofit, 501c3 or 501, well, it's not on here, but anyway. So it would have to go through the Research Foundation. So what happens sometimes is the proposal already went through UCF, and by the time it gets to this portion, it's too late. You can't change who the funding party is, and you can't transfer the funds and whatnot. So this is something to keep in mind way back in the early stages about whose name UCF or the UCF Research Foundation is going to go on the proposal to somebody to fund something where you think this is some sort of activity that you might need. Contracting party name, this is also important on both sides. This is the statute that specifies the university name. We can't put the name as certain colleges or institutes. Those are not legal entities. We say the University of Central Florida Board of Trustees, that's by statute. And the Research Foundation, when we enter into research contracts for the Research Foundation, we include this language, the legal name of the Research Foundation, but we also include acting as a direct support organization on behalf of and as an instrumentality of UCF. And why do we do that? Because there's case law that says a DSO that's acting as an instrumentality of the university gets the same sovereign immunity that we talked about a few minutes ago and protections. So we want to keep that language in there to, it's not an all necessarily perfect solution, and it's not going to necessarily mean, but it's one more piece of the factor to try to keep that position and protectiveness. Recent changes in Florida and federal statutes have to do with indemnification, service contracts, independent contractors, and international data rights. Indemnification. So when we talk about indemnification, this comes up a lot. So when a contract has an obligation for UCF or one of its entities to indemnify somebody else, what we're saying is, whatever happens here, you guys are going to have you, the other party, aren't going to have to pay anything. If you get sued, and sometimes it's even further, or some people you do business with get sued, it depends on the language of the indemnification. If anybody gets sued way down the line for something to do with this, even if we're not involved in the thing that caused the suit, but maybe they took something we gave them and did something else with it, and then somebody gets sued, we're going to totally pay for everything. We're going to pay for all the attorney's fees. We're going to pay for all the damages. We're going to pay for everything. And you guys are going to pay for nothing. And that is why we don't like that, because we don't want to pay for all that. And it's unlimited. So what happened in 2016 was, before that date, we had a attorney general opinion here in Florida that said, no, state agencies cannot indemnify. State agencies cannot increase the waiver of sovereign immunity beyond what's already in the statute. It can only be done by the legislature Well, now we had this case, Florida Department of Transportation and somebody, and what that case, and this went all the way to the Supreme Court, and they said, no, actually, that same contracting power that I talked about earlier that gave us the breach of contract with no sovereign immunity is the same reason that the Supreme Court said, if you can contract, then you can agree to indemnify in there, and you have no limits whatsoever. So we used to say, to the extent permitted by law, because we thought law didn't permit, so we weren't really agreeing to anything. Well, now we can't say that anymore. So now what we try to say, we try to get out of it, but if we just can't, because we want to try to find a way to make things work, we say to the extent and only to the limits of the 200,000, 300,000 that's set forth in the statute. That's still not perfect because we might be indemnifying for something else that's not even in that statute. And we try to make it so the limit is applicable no matter, but we don't really know if it came down to it, you know, how the case would come out. So it's still risk in there, but this is the best that we can do. So just to reiterate, breach of contract and indemnification, no limit, no limit. And for example, if we were indemnifying somebody for patent infringement or copyright infringement, those damages can be hundreds of millions of dollars. That's damages. That's not attorney's fees. And attorney's fees are a lot. Other changes, the service contract addendum that I mentioned earlier, where they talk about, you know, the service contract providers complying with public records obligations, that has changed about 3 times since its inception. So a lot of times people say, well, why do we have to look at these contracts that have been renewed? You know, it's the same as we've had. It's been reviewed before. Why do you have to look at them again? We have changes in the law that we have to make changes. So there are things that need to be updated. And another recent change, which has new support here through Joel Levinson's office, has been very helpful in independent contractor status. We used to not have the same level of scrutiny in that area, but the IRS doesn't handle those quite the same. And so there's a whole kind of questionnaire, especially where independent contractors are individuals as opposed to an entity. Data rights is another area that's changing. All around the world, there was a big seminar that was put on about the GDPR, the European Union Data Protection, and those same obligations are really pretty much worldwide outside the United States. And it gives the individual very extensive rights in being able to reclaim their personal information, and that is very broadly defined. So those things come into play when anybody is outside of the United States. So it could be where we have, for example, human subjects participating in a study, whether it's a survey or in person. It could be, you know, students over in a European country or in another country of the world, or any faculty member traveling somewhere performing research. All of these, it's about where the person is when the data is generated. So these are challenging laws that the data rights is not specific to Florida, but everything else is specific to Florida that I've talked about so far. And I think that is the end. Now, Svetlana Strom, she's Director of Technology Transfer. She's going to talk about NDAs and MTAs, in addition to all of the issues that I just mentioned, which do come up in those as well quite frequently. She's going to talk about quite a bit more. Oh, unless if somebody wants to ask some questions, I forgot about that. Yes?
So I have a question actually on behalf of a faculty member from the Department of Biology. But I also have a question about, I like to know the data that was presented for the introduction of this section that says that, so try to explain me if 75% of the cases that require review by legal are reviewed in 5 days, and 70% of the contracts are executed within 2 months. Are you telling me that OR is responsible for 91% of the time that takes a contract to get established? Is this what I have how should I read this information that was presented by Liz Klonoff, please? Is this
So in the 2 months is the total from theoretically in the door, or when it gets put in cobblestone, to all the way it's executed. So if 2 months is 60 days, the average,
so it only goes into legal for 5 days?
right, there's a whole series of activities that occur.
So the main delay in establishing contracts is not an issue with legal, it's an issue with the Office of Research. Is this what I'm
Well, you're probably not asking the person who will give the same question answer as somebody else. Of course not.
So it goes back and forth, right? And so here's the problem. It is not a simple linear thing. And so the 5 days actually could be 5 iterations. It goes one place, it comes back, Sandra looks at it again for a day, there's day one. It goes out again, the sponsor keeps it for 3 weeks, comes back, Sandra looks at it, there's day 2. I mean, so the 5 days is a part of what our new system hopefully will allow us to do is look at the life cycle of the contracts. Right now, we're just pulling data and we're pulling numbers. So you're asking a life cycle question that we can't answer currently, but it's an important question.
So the question I have on behalf of the faculty member is the following. So yeah, I kind of understand how complex could be this reviewing according to the laws of the state of Florida. But what about those contracts, and we have many, who are actually a continuation of a contract that is being ongoing with a particular sponsor for many years before?
Why don't you let me answer that question in the 4th section? So hang with us, all right? Okay. Now Svetlana. Oh, no, there's all. No.
Hi. The question is, when you're talking about the international data, we've been told, our College of Nursing now, we're not allowed to bring any international students into our PhD program. We were told that we can't do that because of the problems related to, and it's an online course, so they would live in their same country, and they possibly would do their research there. So what are the issues? I mean, if he keeps the data there and then, you know, I mean, I don't understand why.
That come from my office?
Yeah, I mean, it's
Okay.
the same laws that
Okay.
you're talking about. So I
Yeah.
can't answer like in the business decision and as
Yeah.
far as student enrollment. But in generally speaking, what is the right of the individuals under these laws is any personally identifying information, which can include their emails. I mean, it's very broadly stated. Then in any of those situations where if they're there, then they have the right to contact whoever is the recipient and say, give me all of that back right now, period. You have not one single shred of it left, and I now have it all back to me. And if you don't, then there's a set out super high fine, by the European Union at least, with respect to that. Now, you know, there's a lot of different questions about enforceability and blah, blah, blah. But so as far as international students, that would be a good question for probably Scott Cole or Yandi Cook.
Okay.
Because I don't know the decision making.
This guy was from Canada, and I don't even think of it as another country because I
mean,
real
really,
close to
almost
it.
all countries besides the United States have
Yeah.
this some form.
Yeah. Okay.
Well,
Thank you.
This is. I just looked at Tom. This is so. If my office has said that, I think I would know, but I don't know from where that came. So we'll certainly look at it and see whether or not that's actually the case. You have a question, Michael?
So the title of this presentation is why can we not be MIT? So I guess I understand why, but the question is Boston or Massachusetts has probably more liberal laws than we do, right? Have there been any bad cases for MIT that they had to pay hundreds of millions of dollars for contracts that they would enter in different laws than Florida? And if not, why do we bother?
Had to guess, there would probably be some situations where MIT was sued and had to pay some damages, just like we have. But we can't, the laws for Florida are what they are. We can't be in violation of the law as a state entity. So we have to respect those. We have people who can potentially try to communicate through different appropriate mechanisms to make the legislators aware of these challenges. That would be my dream. That happens.
Svetlana?
Good afternoon. I will be talking about material transfer agreements and non-disclosure agreements. And I got a cool charge-on slide, so that's very nice. Okay, so what is our goal in being the office that actually processes these as opposed to having the individuals and researchers sign these agreements? Well, our goal is to protect the researchers, all of you, and the university, and to ensure that the publication is unrestricted, intellectual property is protected and is available, and that compliance is maintained. So I will go into details on all of these. So some of the tools that we use to protect the researchers are, as we mentioned, non-disclosure agreements and material transfer agreements. So just for clarity, non-disclosure agreements and confidential disclosure agreements are the same thing. They're also known as secrecy agreements. That's all the same type of agreements. And the material transfer agreements, of course, deal with the transfer of materials. So both NDAs and MTAs are legal contracts between two or more parties, and they document exchange or transfer of information or materials. So I will talk about these kind of together as much as I can and separately when the difference are distinct and worth mentioning. What is the purpose of non-disclosure agreements and material transfer agreements? So obviously the purpose is to document the transfer of information and materials. It's also to specify the conditions for use of information and materials, to stipulate various additional criteria and obligations, and then to stipulate ownership of the information and materials and what's derived from them and modifications. So we'll cover these one at a time. So we talked about the importance of these documents is to document the transfer of information and materials. And so to do that, the agreements always identify the disclosing and the receiving party, or provider or recipient institutions, as they're called in material transfer agreements. And it's important to know that typically these are the signatories on these agreements. It's usually not the technical or the business representatives, which are also identified in these agreements. And oftentimes, if we were to have technical or business representatives sign, the other entity would question as to whether they truly represent the institution and have the authority to sign these agreements. And of course, our office, the Technology Transfer Office and the Contracts Office, has the signature authority to sign these agreements. So the other aspect to these agreements is that, of course, define what is the information or material that is being transferred. So, so we'll start with information, and I'll cover materials in the next slide. So information in non-disclosure agreements, it can be business or technical information, and it should be described specifically enough so that we know what the agreement covers, just to put some boundaries around what is the discussion topic. So one example of a good description, and this is just a sample, is to kind of talk about the software that's going to be used in a particular meeting that's going to be demonstrated, and the purpose of that software. So that's kind of an example of a good description. Not so good is the example at the bottom. And so keeping in mind this is a non-disclosure agreement and should only capture information, you could see that this definition describes information as including tangible objects, various documents, descriptions, prototypes, samples. So it basically includes actual tangible things that you could make out of that information. So it's very far-reaching. And so I'll talk about what are the implications of that. That's actually case study number 1 that I will get to a little bit later. So this definition is from an actual example of a contract that we were processing. So in material transfer agreements, materials, the lights come on. The material is also defined, as well as typically derivatives and modifications are defined. And these should also be described specifically. And And so they shouldn't include other things that are created by a recipient. So this is kind of a scenario where in the ideal situation, the material that you're receiving is just the original material that the provider is giving you. It could be a widget, it could be a cell line, a mouse, whatever it is, it's confined to just that thing that you are receiving and not different things that you would derive from these materials. So the first example, the good one, is that the material is the original material that's being transferred and doesn't include other things. Now in life sciences, it typically would include progeny and unmodified derivatives because it's only fair. If you're receiving a breeding pair of mice, that doesn't mean that you can go ahead and breed them and all the pups and all the other lineage belongs to you and no longer belongs to the provider. So in life sciences, it is typical to have the progeny and the unmodified derivatives be included in the definition of materials. But what you don't want to have included are the things that you would make that do not contain the original material that you received. And so here's a definition from which we'll get back to as a case study too. That wasn't an actual agreement that we negotiated. And it said that material is original material and any derivative material, including other material or product that is produced by the use of the material. So that's very broad, anything you produce by the use of the material. So if the material is a piece of equipment and is part of your study and you generate other things and use it over and over, this could be interpreted that the provider of that equipment owns everything you do going forward from that equipment. So not a good set of terms. So we would want to negotiate that out. Okay, so the second aspect of NDAs and MTAs that's important or that's part of these agreements is to specify conditions for use of information or materials. So there's usually specific purpose. So in non-disclosure agreements, we'll say the purpose is evaluation as far as entering into a business relationship. Or it could be a specific project. For material transfer agreements, we usually describe the research in which the material will be used and provide a brief statement of work. Typically, these agreements will say that the information that the recipient is receiving cannot be used by the recipient for anything other than the purpose. That's pretty important, especially if we're the provider. Oftentimes, I would see agreements that just say the second part of it, which says, oh, here's the information and you can't disclose it to anybody else. Well, that's great. That's at least the minimum that the agreement should have. But it should also say that the recipient can't use it for other things. Otherwise, they will benefit from the information that we provide incorporated into their technology, their area. So we want to make sure that we say it cannot be used or disclosed. So those are really two critical elements to a non-disclosure agreement. For material transfer agreements, it's kind of obvious that the material should only be used for the specific research that has been outlined and cannot be distributed to third parties. So that's just the minimal of the restrictions. Okay, and there are also other obligations and restrictions that are typically found in non-disclosure agreements and material transfer agreements. So there's publication, which I'll go back to in a second. And sometimes in material transfer agreements, there's a provision for reporting the results back to the provider. There could be an acknowledgement section talking about how you are to refer to the provider and the material that they gave to you. And there could also be liability provisions, and Sandra touched a lot on those, so I won't go into that. As far as publication, so that's really important. We want to make sure that your right to publish the results is unrestricted as much as possible, and really we want to make sure that you're able to do that. So one of the things we look for is to make sure that the results are not contained in the definition of confidential information. That could be very sneaky. A lot of parties will do that, and then, so it kind of sounds okay because you're like, oh, confidential information of provider, sure, we will never disclose that, that makes sense. And it turns out that what you're generating is part of that definition, and now you're prevented from really publishing it. So that's one of the things we look for. We are able to delay the publication, typically no longer than 90 days, and I try to negotiate it for a much shorter period of time so that you can go on with your business and publish. But we can allow the sponsor or the provider to review the publication to make sure that we're not releasing any of their confidential information, and to file for patent protection. That's something we could be filing or they could be filing. It depends on the other terms. So we do typically agree to delay, but we definitely don't want to give the opportunity to the provider to delete anything or to hold up anything that we do. So that's really critical. Okay, and then this is probably the biggest piece of these two agreements is the provisions that stipulate ownership of information and materials, as well as derivatives and modifications. So what I'm showing here kind of again is the ideal case, and that's why I put a little best practices icon there. So in the ideal case, what is owned by the discloser or the provider is just the original information or the material. And what is owned by the recipient, and I talked about this a little bit earlier, is other things that the recipient develops, derivatives, modifications, data, results, basically anything that the recipient creates that doesn't contain the original information or material provided by the provider. So also ideally, these types of agreements don't contain intellectual property transfer in them. They often do, however, which is why it takes time to negotiate them, and that's why we look at the terms very, very carefully. So I wanted to go through these case studies that I mentioned earlier that illustrate the little sneaky provisions that are in there that reach into our intellectual property and transfer those rights to the provider. So. So case study number one, I'm loosely disguising this world-famous amusement park and calling it Worldwide Studios. So Worldwide Studios wanted to enter into a discussion with us about their need, and again, I'm kind of disguising it, but artificial intelligence and self-driving vehicles and people movers and all kinds of fun stuff that they want to have in their amusement park. And so they basically wanted to meet with us, and our faculty would tell us the different problems and the different areas, the issues that they have, and we would then submit proposals to solve the problems that they outline. So far so good. This is where that problematic definition comes in. Sorry, I thought I don't have a pointer. So information, as I mentioned kind of in the earlier portion here, is not just information, it's defined as tangible objects. In fact, they say that. So now it's not just the information that they share with us about their problems, but it's other things. It's the actual things that we would then develop from that information and pitch back to them. So we see that the broad definition here, tangible objects, various documents, descriptions, prototypes, samples, equipment, concepts, all kinds of stuff. But here's the other piece that's problematic. In this agreement, they also define what is a derivative. So part A of that definition is okay, because we can all agree that that kind of could be considered a derivative in the way we would think of it. But part B is now reaching into any improvement on the information that they provide to us. Well, that's something new that we would develop. So now it's part of the derivative definition. And then part C is even worse. It just says any new material that's derived from the information, including new material which may be protectable by copyright, patents, and trade secrets. So that's a very broad definition. So what's the problem? Well, then further down into the agreement, they say that the information and the derivatives are the sole property of the disclosing party. So in a way, you could say, well, what's the big deal? It depends which side you're on. In this example, we're on the receiving side for the most part. So this Worldwide Studios group is going to tell us, like I said, about their problems. So we're pitching proposals, a full proposal where we're suggesting how we're going to solve that problem, the background intellectual property that we have developed, that we sometimes rely on as our know-how in future research. Now, all of that is going to fall into the definition of derivatives, or it could. And so we could be really compromising our intellectual property landscape and our opportunity to do continued research and to do continued sponsored research by signing something like this. So just as a side note, I looked it up. How did we get around it? So we actually agreed to this awful thing, but before you kind of start throwing things at me, for one meeting, because we had to move things forward. So we agreed to do this for one day, one conversation, and we're working on a master agreement that gets rid of all of this other stuff. So it allows us just to have the conversation to see if it's feasible, can we have a business relationship? So we did move forward with this one, but a master agreement with way better terms is in the works. I'm looking at Sandra. Okay. So another problematic case, and this is with a material transfer agreement, and I didn't even disguise the party this time, mostly because it's a nonprofit. Of all the kind of ugly languages we see, we get a lot of them from companies, but it's rare to get it from a nonprofit. So this is with a Wisconsin Alumni Research Foundation, and it's for a stem cell line. So this was very sneaky. You're kind of going along, and it's like, I think, paragraph number 2 in the agreement, and it just says, oh, hey, we agree to stop using the material and any derivatives of the material, and we'll destroy it all. And then it kind of goes in and says, oh, yeah, and the derivatives are basically materials or products that are derived from or produced by use of. That's really broad, or that wholly or partially incorporate the material. So, and then it goes on to say, oh yeah, and then we can't use the results of any study using the material. And again, this is a stem cell line. We would be using it for lots of things. We can't file any patent applications on it, on any results that we generate. So it's pretty ugly. So this is just showing what we ended up agreeing to. We got rid of the produced by the use of, because that was very broad. Now derivatives are just simply things that are derived from the, or wholly incorporate the material. That's fair. And then we said, basically, we will not file any patent applications that incorporate their information or their materials or the derivatives narrowly defined. So that's way better. And then, just to be clear, we've added a statement of, okay, notwithstanding all that other stuff, data and results that we generate are ours, and we can do whatever we want with them, basically. So that freed us up. So that was a good solution to that agreement. So this is a really, really well-known kind of example that has very far-reaching implications. And it went all the way to the Supreme Court. So, but it's complicated, so bear with me. Okay, so there was this researcher at Stanford. It's known as Stanford versus Roche, and you probably heard of it. This researcher at Stanford, Dr. Holodny, was working, it's a Russian name, so I pronounce it in a Russian way. So he was working on a way to quantitate the presence of HIV or HIV levels in patients. And he was using a technology called polymerase chain reaction, which at the time was pretty new. It's a way to amplify DNA, so very tiny amounts of it can be detected in patients. So like I said, at that time it was revolutionary. Eventually the guy who developed it won the Nobel Prize for Medicine. But anyways, like I said, at that time it was pretty new. So to learn more about it and how to use it most efficiently, this Stanford researcher visited a company called CETUS, and that's a company that developed this PCR technology. And so he went in there to learn about it. He developed this HIV detection test and disclosed it to Stanford. So Stanford then obtained 3 patents on this disclosure, on this invention. And then in parallel, a company called Roche acquired CETUS, and then they commercialized the HIV detection test. And in using the technology that was developed by Dr. Holodny while he was at CETUS. So Stanford saw that this test is on the market, and they sued Roche for infringement of their patents. So here's the important piece of it. So Dr. Holodny, when he joined Stanford, he signed an agreement, a typical employment agreement, that said that he agrees to assign right, title, and interest in inventions resulting under his employment at Stanford to Stanford. So, however, when he entered CETUS, he was given an agreement to sign. And he signed it, and it was a non-disclosure agreement. It seems kind of not a problem. You know, he's going to be working there, seeing their stuff, seeing their technologies and their kind of secret sauce, and so it didn't seem like it would be problematic to sign the non-disclosure agreement. However, when I kind of said, you know, ideally these things don't have intellectual property provisions, this one did. And this one said that he will assign and does hereby assign his right, title, and interest to each of the ideas, inventions, and improvements as a consequence of his access to CETUS. Wow, that's broad. So, to whom did he actually sign his rights? So, as I mentioned, so this went through the court system. Roche actually argued that so when Stanford sued them for infringement, Roche said, oh no, we jointly own it with you. Because we get the rights from Holodny, because he signed it to us, and you get the other co-inventors. That's how your rights flow. And so basically Roche saying they don't owe him anything because it's jointly owned. And they of course reveal the confidentiality agreement that was signed. So Stanford took kind of a different strategy to this. So because this research at Stanford was federally funded, they basically said, oh no, Dr. Holodny didn't have the rights to give to you, to CETUS and to you, Roche, because he never had them. Because by virtue of federal funding, the rights to his intellectual property went straight to Stanford. So this went through, like I said, different courts, and the Federal Circuit basically found that that's not, they disagreed with that interpretation and that with the federal law, which is called the Bayh-Dole Act. And in general, as a side note, inventorship rights go all the way back to the Constitution, Article 1. So they kind of said, no, this doesn't bypass your rights as an inventor under the US Constitution. And so, in fact, the rights did go to the researcher. And oh, by the way, the terms in the Stanford agreement, employment agreement that said agree to assign, that's just a promise for some future kind of time frame. Whereas the language in the CETUS agreement, where it's hereby assigned, gave it to CETUS right then and there. So not only did the researcher have the rights, but he gave them away to the company. So that was the Federal Circuit decision, and the Supreme Court agreed with that. And so Stanford basically lost that case because they never received the rights from the researcher. So interestingly, the consequences to this, just last year, last May, the federal law, the Bayh-Dole Act, was modified to now require that we, the employers and the recipients of federal funding, have an agreement, a written agreement with each of our employees that that ensures obligation of those employees to assign, to disclose the intellectual property, the inventions, to us, the employer. And the language says, and hereby assigns the rights to us. And so these agreements have been distributed to all of you, and they're in the works, and that's a change in the federal law. It took a long time to get there between 2011 and 2018, but it's there now, and that's the requirement, is to make sure everyone discloses and assigns the intellectual property to us. So I think that's my last slide. Is it? Oh, sorry. One more, just to summarize. So why do we want to be the ones to review the agreements, and why can't you kind of sign them and hope for the best? Because we're ensuring all these different aspects in these agreements. We want to make sure that you are able to publish. You don't want to be in a position when you think you have it, you publish, only to have the companies or the providers of information come after us and say we're in breach of contract. And we want to make sure that the intellectual property that is developed from under any of these agreements is really available for further teaching and research purposes, and you can use it again in other privately sponsored research, so it's not locked up with one particular provider. And we want to protect the knowledge and the know-how that you are gaining, that you have as your platform and your research base for future research, and so your students and postdocs can benefit from all that and can walk out the door and apply it everywhere else and not be prevented by some far-reaching, ugly agreement that happened, in the past. So really, that's the purpose, is to safeguard the university's intellectual property and to be compliant with all the different laws and regulations that we have. What I didn't have time to go into, and I know this is already long, are any kind of human subject research rules and regulations. Those are the things that we check. So when we're getting human materials, we want to make sure that there's IRB approval in place, that the materials were collected under proper IRB protocols, the consent forms were properly signed and allow further research and allow us to receive those human materials and to develop other things with them. So there's a whole other number of things that we look at. We look to see what other prior agreements there may be in place that could have restrictive rules or far-reaching kind of restrictions in them that will prevent this new type of research or these new projects that you are coming to us to look at. So that's what we're here for, and hopefully we do it quickly and efficiently and collaboratively with all of you. I think that's it. So I'm happy to answer any questions.
I see that Stanford lost out on a good invention. How about the faculty member? Did the faculty member lose out on anything?
So I looked him up. I looked him up today. It's really interesting. So he's still at Stanford. He's an MD, and he works in infectious diseases. He's at their Veterans Affairs hospital. He's still there, but when I was looking at patents, he only had those 3, and they've already expired by now. So I don't know if there were any repercussions. I mean, this was kind of a big case, but.
I sort of meant the other way around. Did you make any money?
So that actually leads me to, it's a great question. I wouldn't really know, personally, but generally, but generally speaking, companies don't reward employees for inventions, whereas universities do. So I would guess he would have been way better off reporting it to Stanford. Not he didn't do it maliciously. He didn't try to go around Stanford. I think he was a very collaborative, well, he's still there, collaborative and participant in all this legal process, but he would have gained a lot more had Stanford been able to commercialize it, because like us, they really distribute the royalties from intellectual property. So I think he didn't get as much as he could have. But at the time, that was a huge revolutionary test for all of HIV detection. So it was, yeah, very big. Yes. I was told I have to go. One more.
Hi, Svetlana. Some of the NDAs are no more than a page long. Just like we fast-track some of the contracts, could we fast-track NDAs and MTAs as well?
Yes, so we have template agreements that we can do very, very quickly. We definitely have template NDAs that are ours, our version. So we can provide ours. It's very fast. It doesn't even have to have legal review. Absolutely, easy to go. We have template material transfer agreements. Most of them are like biological, but we have there's some that are more for physical kind of materials. Well, so those will have to be reviewed. It's all those different issues that Sandra and I pointed out. As long as we can, they're reasonable, it don't restrict you unnecessarily, and don't take your intellectual property. We can. It really depends. It depends what you're doing. It depends. If some of those terms may not be a factor, they may look horrible. That just won't matter for a particular statement of work and for a particular interaction. So we work with you to make sure we fight for what matters, not just fight. Okay, thank you. Oh. Dorothy.
Do you want to introduce yourself?
Sure.
Okay, go for it.
Good afternoon. I'm Dorothy Yates. I'm the Associate VP for Research here at UCF. I've been here not quite a year. May 4th is my first year anniversary, so it's been quite an exciting time. I wanted to start out, we're talking about why reports sometimes aren't the only acceptable thing for putting in for final reports for deliverables on research activities. And many times in federal grants, it is typical that you would just file a report and that would be your deliverable for that project. But it is not so true when you're dealing with private industry funding. Very seldom will a report suffice. They really want to know more specifics, and it could be anything from a robot, a piece of experimental equipment that you're creating, or a newfangled telephone. Lots of different things that happen in this. So we're talking about the statement and scope of work, and according to UDIP, the University Industry Partnership, an industry-sponsored research statement should identify the following: the principal investigators and the project staffing, a description of the research to be conducted, where it will be conducted, project objectives, and any special resources required. It should also have the period of performance identified, timing and frequency of meeting and reports, and the deliverables and milestones defined in a sufficient level of detail so one can consider that they have been met. So you have to think about what you're trying to do. Sorry. Okay, so deliverables for industry-sponsored projects often need more detail. You describe the deliverables carefully and with sufficient detail to eliminate ambiguity. This is something that we're always concerned about, and Sandra has a lot of good information on this, as well as all of our contracts people. It's what they do. So we may be coming back to you to ask you for additional detail when we're going through these contract negotiations.
We need to ensure that both the PI and the industry partner have a clear and common understanding of these deliverables. It should be consistent with the statement of scope of work and the project purpose, and it should specify due dates. Now, I think about this as when I give my husband a grocery list. You know, I'm getting ready to make something and I need sesame seeds. I only need like 2 tablespoons of sesame seeds, but I'm not thinking, I just write sesame seeds on the list. Well, I get the large economy size of sesame seeds, and basically it's not it's not his fault that we now have a lifetime supply. It's the fact that I wasn't clear in my description of what my expectations were. So deliverables are, you think about the deliverables in the same way. So what are some of the best practices? Is that the PI and sponsor should have a conversation throughout this process to where they have an understanding on the format, the content and specifications, the deliverance, deliverable performance, frequency, and mode of delivery. Now, one of the things that a lot of times that people don't understand about this is it's not just your scientific counterpart at the company that needs to understand this information. This goes back to what Liz was saying earlier. If we want to get paid for the work, other people within the company also need to understand it. So it needs to be written as much as possible in layman's terms so that the accounting director can understand it that's issuing the check, those types of things. So it's important to know that this cannot just be totally scientifically based when you're dealing with companies. It really has to be clear and concise to a non-scientist. So we have an example here. A bad example, a PI will produce a weather sensing widget. So to give you more detail, a PI will deliver develop the widget in her campus lab. The widget will be solar powered. The dimensions will be no larger than 8 inches by 10 inches by 4 inches. The widget will be designed to be fully charged with 1 hour of direct sunlight. The widget will be constructed from high density plastic material. When fully charged, it'll be able to predict expected precipitation for a period of 5 days before needing to be recharged. The widget will be tested a minimum of 6 hours to ensure that it meets 6 times to ensure that it meets requirements. 30 days prior to the end of the project, the PI will demonstrate the widget and deliver it to the sponsor along with the details on testing, and the sponsor will have 30 days to review and accept. So this goes into much more level of detail, things that are agreed with on both sides that can understand exactly what they're anticipating. So we have some cautions, which is pretty typical. The university-based projects typically do not produce manufacturing-ready prototypes. These come directly from Sandra. Thank you, Sandra. And then stay away from terms like fully functional and production-ready. Those have different meanings in the commercial world than they do in universities. So there's certain things that you do want to avoid. And mistakes to avoid are using vague language and terms, and we talked about that. Using language that doesn't translate well. Failing to ask for feedback on clarity of scope. If you really want to write a good scope, a good detail, is get somebody else to read it and see if they can understand it. And try to get a non-scientist to read it, even better. That's very helpful. Undefined acronyms and terms. In higher education, we tend to use a plethora of acronyms and often don't define what they need. So it's really important that you do have definitions for those. And you also need to see when it's unclear, don't have one that's unclear on how to determine the project's success. You need to have a stopping point. You need to know when you're done, when that's ready to go and ready to ship off to the sponsor. So that's pretty much what I had to say today. It's the scope of work can specify both what is in and what is out. So if you need to put something in there that says this is not to be this, or understand that, that's something else that you can do on your scope of work. So that's all I had, Liz. Are we caught up on time? Any questions? Keep pressing them on.
All right.
You're back. Do you want?
So the big question is, what do we do with all this information? So some of it you need to know, some of it we need to know, but let's see what we may want to do to kind of change how our process works. So, the legal process with which you are all familiar says all changes to agreements require a fresh attorney review. So, you do something, we send it to legal redlines it, we take it, we send it to the sponsor redlines it again, it's got to go back to legal. Legal looks at, remember I talked about the back and forth with the 5 days could be 5 separate iterations. And so 14% actually of the attorney reviews result in what has affectionately come to be called recycled agreements. That is, agreements that go back to the attorneys for re-review. For the past week, I know you feel it all already, but for the past week, we've begun to use a new review process, all right? In this review process, there is no more recycled reviews. So only one legal review is required. And what happens is, rather than actually editing the language itself and changing what's said, etc., what the attorneys do is they make comments on the legal and the business risk issues, all right? They note those issues that must be addressed prior to execution, that is something that's illegal, and they note those things that are high risk, that is something that you may want to think about that is not necessarily illegal, but something that you may want to consider going forward. But the agreements themselves will no longer be redlined. Each agreement at that point then will be approved for execution subject to the consideration of the attorney comments, all right? So it's we affectionately call it one and done now. Those things that in the attorney's review they feel are high risk will be actually routed to either Dorothy or me at that time, so that business decisions that may need to be made can be made after the first review, so that as it's being done, before it goes back to the sponsor, we can talk with the negotiating staff and work through whatever needs to be worked through, so that hopefully we won't be recycling from the sponsor as well. The advantage of this is, of course, the attorneys will still be available. If we have an issue, and I can't tell you how often I have everybody on speed dial to call and say, ooh, gosh, can we do this? Can we not do this? Do we really want to do this? So the attorneys are going to continue to be available to talk with the negotiating staff, to provide guidance, particularly when it comes to risk or problematic terms. And if the negotiating staff wants, they can actually recycle it again. If for some reason, you know, the negotiating staff feels like there's just too many red lines and it's getting too confusing, it can still be recycled. The difference is it doesn't have to be recycled. So we've done this for a week. I know you all are just feeling the effects all over the place, aren't you? In 5 months, we're going to look at whether or not this has made a difference, whether or not it's cleaned out some of the inboxes, etc. We're going to look at a random sample of executed agreements, and we're going to get an outside entity to look at the quality of these executed agreements to see, you know, how much people went along with the comments, etc., how far apart things were by the time the contract was executed. In addition, and this is important, we're going to reach out to you to see whether or not your experience of this process is different. Now, in the 5 months, we'll be just about getting ready to actually implement agreements, which is the whole new system where you'll be able to, when you submit your PTF, there you won't be submitting your PTF anymore, you'll be submitting it in a single system. and you'll be able to log in with a single login and actually see where your proposal is through the system, including when we've received the contract, how we're doing. You'll be able to log in and see where your contract is, whether it's with the sponsor, whether it's with our negotiating people, or whether it's still in the one soon to be done stage. That will give us, as you can imagine then, the ability to do the life cycle, which is something that we've missed now with the back and forth. We'll be able to track the life cycle of all the proposals from the time you submit it to the time that it's actually won to the time it actually has an account set up, because it'll all be done within this system, which will keep track of the dates. By the way, for those of you that are interested, Faculty Senate will be having this month's Faculty Senate meeting. We're going to be demoing the new system. So if you really want to see it, please come and see it. We also are involving departmental administrators, faculty, deans, etc. We have a committee with deans serving on it in order to make sure that the system that we develop is maximally flexible as much as it can be, and that is responding to the needs of all of the users as well as we can. Finally, then, I think you raised this issue that when nothing changes, why does it have to be reviewed? And now, if it's just a simple modification, change in date, change in dollar amount, nothing else has changed, it won't have to go for review, not even the one and done. All right? I think, is that it? I think that's it. So, questions, comments, screams of agony. Yes, ma'am.
Dr. Klonoff, so if I'm the director of a PI of a grant, and I have sub-grantees that go out, and once that agreement has gone to legal, they've made suggestions on it, or done what you said, none of them are illegalities, so it doesn't go to you. Who does it go back to?
No, not illegalities goes to me. Business decisions. So it will go back to our subcontracts group to make sure that it meets criterion. It is only if what you're proposing to do is risky in some way that it will come back to us. So my favorite example of risk, I don't think she's here, is the cup of dirt. So in my first year here, someone had a $20,000 grant to put a cup of dirt in the Vomit Comet. You all familiar with the Vomit Comet, the plane that gives you zero gravity? And so for a $20,000 grant, we were asked to spend $10,000 of that on indemnification insurance because, you know, the plane could crash or the dirt could get in someone's eye or whatever. And that was a business decision. We decided at that point, given that the Vomit Comet seems to work all the time and that if the plane crashed, the likelihood that they would get around to suing, this was a business decision, the likelihood that they would get around to suing on the basis of that cup of dirt having caused the crash was so minuscule that we elected to go naked, to not get the insurance. And sure enough, I think the flight was successful, and to the best of my knowledge, no one got dirt in their eye. So those kinds of business decisions, you know, what are we going to do? Those are going to be made by Dorothy or me.
But if it doesn't need that, and there are suggestions that the attorney writes,
it goes back to the negotiating staff who who will be negotiating with the subcontractor or the sponsor. Yes.
What is the time frame for the turnaround if it's thank you. If it's a high-risk proposal or contract and it has to go to you or Dorothy, what's the time frame for how long?
I think we've gotten pretty good at doing it that day to at least, you know, now I may be out. You know, Dorothy may be out, but our goal is if it gets to us, we're going to really try and deal with it. And don't be surprised if we don't make an obscene phone call to you saying, okay, what are you doing? What are you trying to do? What's your goal here? Because, you know, so one of the things that I don't think has been said as clearly as it needs to be said is I understand that the experience is as if it is thwarting. The experience of the Office of Research is as if the goal is to make sure you cannot do what you want to do. In fact, that is the last thing the Office of Research is trying to do. The Office of Research is trying to do two things. One, protect you, and protect you from things about which you may not even know you are at risk. So, preserving your right to publish, for example, you may think today, what's the big deal? I'm not really going to do anything that's going to be publishable. But let's say you're wrong, and you sign something, and now you are constrained from publishing going forward. We are going to fight, even though you think it's okay, we're going to fight for your ability to publish. We're going to fight for your ability to do all of the things that make you faculty as opposed to a corporation, and that's a very different mindset. And so what's important to know is that even everyone who's here, everyone who represents the Office of Research, even though it feels like the intention is to thwart, the intention really is to facilitate. And there is not a single person in the office who is not dedicated to allowing you to do what it is you want to do in the best way you possibly can for you and for the university. And trust me, having done some research in my history that is very, very risky, I understand that it sometimes doesn't feel like you have my best interest at heart because you really want to do it, and why are you bothering me, and come on, now you're just being stupid. But in fact, there is not a person in our office that really doesn't try to do what is necessary for you to get the research done that you want to do. So one more thing that we don't have the details, but I do want to. I don't like those details. So Dorothy had details and I didn't like them. So we are in the process of setting up one final thing, which is concierge contract services. So there will be a number and an email address. So part of the problem is, in all honesty, you guys wait an unreasonable amount of time before you say, hey, what's happening? All right? So if the contract's been in our office for like 6 weeks and you're only getting around to thinking about it, A, we think must not be too important, right? Or B, we think, well, I guess you're okay with it. So part of what we would like to do is encourage you. So, if we get to that month time period and you haven't heard anything, we really want you to be reaching out. We want you to be calling the person who's doing the negotiating for you. And we want you to do it so much that we're going to actually have a separate pathway for that. We're going to have a concierge service so that if you think it's been a month and you want to know what's up with your grant, just contact the concierge service. It will be their job to figure out where it is. Now, of course, we're also going to have software that will support that. So you'll be able to log on yourself and see where it is. But if perchance you forget your password and you don't want to do my forgotten password or whatever, or you kind of like a personal touch, we'll be able to provide a concierge service that will track down it for you, or if you think it's just been taking too long. But really, we have no way. I have no way of knowing things are taking too long until or unless you reach out and tell us. And really, please feel free to do that. Sir?
I think this new software may let you do it anyway, but I also think it's absolutely critical for you guys to have good tools that don't just show things like averages. I don't really think that 75% in 2 months sounds like a very good figure, because that means a quarter of things take an inordinate period of time. But, if the software lets the contract negotiator, something flashes red, when it's sat in let's say the outside company's hands for 2 weeks or something, so you all can nag them. I think that support of the system is really important. And I hope that the rest of us will get sort of the equivalent of report back data, which isn't just averages, but let's say closer to histograms for our colleges.
That's part of why I want to do the life cycle, because that's really what we're talking about, is that life cycle that's not just 47% of dentists believe you should do whatever.
So with the pre-awards, there is a definitive good outcome that we could all agree, that every proposal is submitted, every proposal. What is a similar outcome for the post-awards? Would you have them done in 3 months?
I don't know. I honestly don't know.
Yeah.
So I can tell you this. As you can well imagine, I've gone on everybody's website and Googled, time for contracts from all of our, everybody talks about 1 to 2 months for most things, and everybody has the caveat, more complicated things could take much longer. And so some of the parameters are, it could take anywhere from 4 to 6 months if it's more complicated. No one will define what more complicated is, but everyone's talking about 1 to 2 months. So I think I will feel pretty good if we really are, if the ones that historically have taken forever or feel like they've taken forever, if we can bring down the number so that it's not 25%, so that we've got most of them going, but there's still going to be, the thing that was striking to me in looking at all these universities is everybody reserves the right to have problematic contracts. And everyone talks about it may take a year or so to negotiate. And so I think the issue, if I were going to try and capture the issue, I think the issue is the private sector and universities are very different animals. And part of what we're trying to do is we're trying to create progeny at the intersection of these two very, very different animals. And so I think for most of the time, it works okay. Like you put two animals together and you're gonna mate them and they're gonna come up with, kids that work. Every once in a while it doesn't work so good. And I think that every once in a while that it doesn't work so good is where it really underscores the focus of the university, which is the generation of new knowledge, versus the focus of the company, which is the generation of more profits. And I think when the contract really has those two foci and they come into conflict, I think it's going to take a long time. Sir.
What do you want us to do? Because you see, what I'm afraid of is, from our side, that we come to you 3 months after the contract has been awarded and it's not signed yet, and blame you instead of blaming ourselves that we are not following up on whether this contract is moving in the right direction.
Yeah, he's going to blame me, so just, go. So I think, with the 5-day rule, it was clear. Let's get this up and running. So, really, this is a week old. I think those are good questions. I think we need to get it up and running and going. And I'll bet you, within a few months, I'll be able to say to you, oh, yeah, well, if you don't call us within 2 weeks, kind of like the 5-day rule, then it's on you. So I do think, though, you really do need to encourage your faculty, when it's with the sponsor, to reach out to the sponsors. Because unlike us doing it, here's my problem with what you articulated about, we have the flashing red. The problem is our folks are not as good at reaching out to the sponsors to tell them to do something as you are. It really is much better if it's your contract to have you call the person with whom you're working and say, you know what, it's really kind of messed up.
I hear that. I just want Dorothy's people to say, I need you to call this person, rather than me realizing it's time. All right, but then I have another question. It's the part we didn't really have time for. We struggle with ensuring compliance in various ways. So I'm a dean. Half my job is making sure people follow the rules. That's just the way this is when you work for the public and we get funding from all kinds of entities, and I believe in it just really firmly. But I don't think we're always very sophisticated as a university, and sometimes our notion of what is required for compliance seems to be insane. And I'm worried about that part of it. We have that continuing to come up. Now, that's not your office exactly, but your office intersects with all of this. And I don't know what we should do to go forward. You've just done one version of it with a one-and-done deal with legal, But now I'm wondering about this thousands of other compliance problems.
Yeah, I agree with you. And, you know, the two Michaels in Baja, we were all in a meeting together last week. And I really think that so here's my personal opinion, so get ready. This could be ugly. I do think that over all the years, at least leading up to my being hired, and that has exacerbated in the past 7 or 8 months, we have conflated compliance and risk in a way that does not serve the university well. And so we have become so risk averse and so compliance seeking that we have forgotten that what happens in other than athletics, I do the most risky thing in the university. And at the end of the day, you can do everything right and still be sued. So we could, for example, have a human subject who filled out all the forms, did everything they were supposed to do, agreed to everything there, tripped and fell on their way in or whatever, sues us, and we're still going to pay. We can never, and no university can. And as we move into doing medical research, it gets even worse. But no university can reduce its risk to zero. And I think we have slavishly sought the zero risk criterion for many years in response, I think, to the university having fallen too far in the other direction. So I guess it is my hope, and I don't know that we'll achieve it, but it is my hope that by operating an office that really does look at these things and monitors and modulates compliance in a way that's meaningful, we can return the pendulum back to a reasonable point. So I agree with you. I mean, and I think that it is this opportunity now for us to make sure that all of our faculty are doing the right thing whenever we can, because then maybe we can stop this I don't even know what to call it. But I agree, we are a little bit over-regulated.
Thank you very much. I was asked to come because we had a meeting in the anthropology department, and we anthropologists are famous probably for doing weird things in strange parts of the world at high risk to ourselves and others. And the questions that we had involved sort of international law and how our intersection with international law. One, what systems are set up? Where's our conservative system that we can call to ask if we have questions about how to work within legal systems in Turkey or Bolivia or in Antarctica or wherever? The second question then is in terms of the contracts that we have or agreements that we have with foreign governments or entities in foreign states. Very often we get pushed into that strange the miscellaneous category that's within perhaps the 10%, where things seem to languish for a very long period of time. And so the question is, what is being thought as to what the steps could be to address that, particularly as we try to become a more international global university?
First of all, I think you're going to need to stay on me about that a lot more, all right? I mean, I think it has been an unaddressed issue, in all honesty. I mean, we just haven't done it. We haven't looked at it. We haven't done very many of it. I mean, there was the EU contract out of Mike's college. And so I think we're going to need some consultation, and we're going to need to get smart about that. We are only now, by the way, Sandra looked at this as it came through. We're only now, by the way, looking at our obligations for international IRB work. And there's one right there. And when you read the common rule, there's some interesting things about what you need to do. And if there's not an ethics board there or a comparable board, that you have to get someone there to say that what you're doing. I mean, so I agree with you. Can I just ask that you really stay on top of me and that we set up a time to sit down and talk about all those concerns? Because I think what we may need to do is get some consultation from some of the universities that do it more frequently but also do it well. Because I agree with you, I do not believe we are doing it well. So, and it's my bad. So, I'm getting the...
Would you please join me in thanking Liz and her team for an excellent job?
Sure, just two.
So if you have further questions, please ask them in this. Please, please have some refreshments, so I don't call all back to
Thank you.
Thank you.